Very simple. We did three, I guess, before we did that. We skipped around. Not a big deal. All right, who's responsible for drafting the Bill of Rights? Mr. Madison. All right, James Madison was. All right, not Ben Franklin. He was, not Jefferson, not Thomas Paine, but James Madison. And remember, Madison didn't even want to include the Bill of Rights. He was against the Bill of Rights in writing the Constitution, the article of the Constitution, but he did say that we would address them later on, and he did. As a man of his word, the first thing that Congress did when they first met after the new form of government took office is they drafted the Bill of Rights. Okay, Madison was the primary architect of it. All right, according to the readings, which of the following provisions have not been formally applied to the states? So that question seeks your knowledge on a couple things. Which amendment actually makes a lot of the Bill of Rights applicable to the states? What amendment is that? 14th, right? 14th Amendment, through the incorporation doctrine, makes a lot of the amendments applicable to the states, but not all of the amendments have been formally applied to the states. Some of them have not been. And the one that I want you to know for certain, I will ask you this question. I may ask you this very exact question, question 2. The Fifth Amendment right to a grand jury in felony cases has not been applied to the states. Now here I give you options, and so even if you didn't know this, you should have thought, well, I know it. Like I would think that, you know, anybody out of high school would be able to answer this question. I didn't take the course, but I could probably still answer the question. The First Amendment right to peacefully assemble. Do I have the right to peacefully assemble in New Jersey?
Yes.
Okay. Do you think New Jersey can treat its citizens or prisoners with cruel and unusual punishment? No. Okay. Do you think New Jersey can force people to testify against themselves and plead? No. Okay. So if New Jersey can't do that, then the only option is the Fifth Amendment right to a grand jury, indictment, in felony case. And I told you, government uses the indictment system. New Jersey uses the indictment system. A lot of states use it, but there are states that don't bring formal charges by way of indictment. It's the tool that they use to bring an indictment. Some use what they call as information. You will see this question guaranteed. All right? Fifth Amendment, grand jury has not been incorporated to the states. All right. And we talked about a case where a guy was convicted of murder and sentenced to death. He goes, wait a second. I didn't have a grand jury in California. You're violating my constitutional right under the Fifth Amendment. They said, no. The Fifth Amendment right to a grand jury is not made applicable to the states. You were charged in California by another means through information. You had due process through your trial. You had a fair trial. The Fifth Amendment grand jury was not part of it, and you're not protected. Okay. What theory of rights is reflected in the Declaration of Independence that says all men are endowed by their Creator with certain inalienable rights? So we talked about theories of individual rights. We have the compact theory, right? It says it's basically what? A contract between the government and the people. And then we had a natural rights theory that says you don't have to have a contract with the government. You have certain natural rights. So what do you think the theory was when they were drafting the Declaration of Independence? Not the Constitution, but the Declaration of Independence, with the language that says all men are endowed by their Creator with certain unalienable rights. Was it compact theory or was it natural rights theory? Natural rights theory. Yeah. Do you see why? Do you see the distinction between the two? Which theory of individual rights was reflected in the United States versus Euryquides? Okay, so that's the guy that was selling drugs in Mexico, right? And they wanted to do a search warrant of his house because they thought he had paperwork there, and they didn't get a search warrant. They wanted to search his house without a search warrant, and they used the Mexican authorities who assisted, etc. But what was their theory? Was he entitled to have a search warrant They said no. They used compact theory. They said, we don't have any, he didn't sign any contract with us. He's not a U.S. citizen. He doesn't have that right. Under your critis, that's what they said, okay? What constitutional provision has been used to make most of the provisions of the Bill of Rights applicable to the states? That's the 14th Amendment due process, okay? That you should know. Most. Which ones aren't applicable? The 3rd, the 7th, the grand jury section of the 5th, and then I think bail of the 8th Amendment has not been made applicable yet. Bail at some point probably will be. What phrase is used to describe the theory that governmental power can be limited by enumerating or listing the government's specific powers in the Constitution? So we have some Latin phrases here, right? Res judicata, I never mentioned that to you, but you probably know it from one of the other courses. I think it speaks for itself. Habeas corpus, we did talk about that one, right? That's petitioning the body, right, before the court. So we know that's not it. Corpus maximus, I think that's the name of the horse in Tangled. No, I'm joking. Maximus is, what? It's Maximus, right? Yeah. I think that's like one of their best shows yet. And that horse cracks me up all the time. But it's inclusio unis est exclusio ulterioris, right? And so, what does that mean, all right? It means the fact that we've included it means it's included. The fact that we haven't included it means it's not included. So, what is the, we did that on purpose. What is the theory to describe the theory that governmental power can be limited by enumerating or listing the government's specific powers in the Constitution? This is what we want included. And that's why we include it. That's where the Latin comes from, inclusio. If we didn't want to include it, it's excluded. If we wanted to include it, we would have what? We put it on the list, put it on the shopping list that your wife sent you to the store. Listen, you didn't bring home eggs. Did you have it on my list, Laura? No. All right, that's why I didn't bring it back. All right? If you want it, you bring it back. What amendment provides accused persons the right to confront? Which amendment gives you the confront? Again, you need to know your amendments, right? So a lot of this test here is just going to talk about amendments. That's the 6th Amendment, right? Most of your trial things take place in the 6th Amendment. The incorporation doctrine, we have, some bills, some amendments were incorporated through the what? 14th Amendment. I wrote 14, and the computer says, no, it's got to be written 14, but it's correct, right? The language in the 9th Amendment suggests that there are other limits or bills, right? So 14th, 9th Amendment, you got to know your amendments. The 10th Amendment there talks about, all powers not given to the United States or taken from the states are reserved to the states or to the people, all right? The 4th Amendment is the next question, right? Unreasonable searches and seizures. Madison did not want to include the Bill of Rights during the Constitutional Convention, so he opposed the inclusion of the Bill of Rights, which is true, but then he ultimately what? Drafted them, right? But not in the actual articles. The Bill of Rights contains an exhaustive list. No, it doesn't. It doesn't say every right that we have, so that's false. All the Bill of Rights have been applied to the states? No, we know some of them haven't. Particularly at least one, I hope he remembers, the 5th Amendment grand jury one. When we refer to the state or states, we also, by implication, are referring to what? Government, right? Local governments and stuff. What's the difference between compact theory and natural law theory? Again, you need to know that compact theory is what it is. It's a contract, an agreement between the government and the people to abide by laws, and in return, the government's going to give you various things, infrastructure, support, etc. Natural law theory says that you have certain rights just by the mere fact that you're a human being. Okay, you don't have to contract it with any government. All human beings should have that. Some of the implied rights or implicit rights recognized by the Supreme Court through case law is There's no amendment that says you have a right to marry, but it's an implied right, right to travel. That's another implied right to privacy. Nowhere in any document, as far as the articles or the amendments, does it say you have a right to privacy, but we know we have a right to privacy. It's implied, case law on it, which is what? Griswold in Connecticut. Alright, so then we had these, so then we're talking about, freedom of speech, right? And there was a variety, there was several tests, right? You had the bad tendency test, you had the clear and present danger test, you had the Levin test, right? You had, so you need to, know these various, tests. So take a look at the cases on outline 2, for exam 2, and know what case represent what. So Gitlau versus New York, that's the bad tendency test, right? Brandenburg v. Ohio, that's the Brandenburg test, right? That's the KKK test. Schenck v. United States, that's the Social Communist Party, that's the clear and present danger test, where he was trying to get them not to do the draft. Which of the following cases actually sided with the rights of individual expression? So out of these cases here, which are First Amendment cases, which ones actually sided in favor of the person? Gitlau versus New York? No. Schenck versus United States? No, they didn't say what Schenck was doing was okay. Texas v. Johnson, that's the flag burning case. They said it was okay to burn the flag. Brandenburg v. Ohio, they actually sided with Brandenburg, even though he's a KKK guy, but because he passed the Brandenburg test, so the answer would have been 2 and 3. Okay, there. This was actually one of the more difficult questions, I think, on this test, because it made you actually say, well, it tested your knowledge of knowing all 4 cases rather than just one, and you had to group them together. Now, if anybody picked the 4th section, which said 2 and 5, you're just not reading, because there wasn't even a 5 option, right? So then, so now you had to narrow it down to 3, and it was either gonna be 1, 2, and 3, 2 and 3, or 1 and 2. So, but if you knew that 3 was Brandenburg v. Ohio, and you knew that the Brandenburg test, that what he did was okay, then you knew that 3 had to be part of it, so now you're narrowed down to be 1, 2, and 3, or just 2 and 3. So sometimes you just gotta work your way back through some of these questions. So here, I purposely did this wrong because I don't want you to make the same mistake. A broadcast journalist, right? So I don't want you to get caught up on journalist if you see it. The key is broadcast. So when you broadcast something, you do what?
Speak.
You speak, right? So when you speak, you have what? Slander, right? Remember, slander is speech. Don't be tricked by journalists. That's my note to you guys. Not that you'll see it again. Okay, with free speech, the idea that you have multiple ideals or forms of expression, that's good. And we should compete against each other. Debate is good, and that is considered a marketplace of ideas. It's good. That's what, it's this term, it's just a marketplace. What case best illustrates symbolic speech? What's the best case that can illustrate symbolic speech? What's the best symbol that we have in this country? The flag. Symbolic speech case, best case, has to be Johnson, right? A law that regulates more speech than is necessary to accomplish the government objective will most likely violate this doctrine. Alright, so there's 2 doctrines that I'm trying to get to here that I want to quiz your knowledge on. The overbreadth doctrine or the vagueness doctrine. Now this question says, the law regulates more speech than is necessary to obtain what its objective was. So it's what? It's overbroad. It's the overbreadth doctrine. It's simple. Miller v. California, you definitely got to know that case. That's the what? Obscenity case. And with the obscenity case, there are 3 things that determine whether or not something's obscene. You need to know what those three things are. Look at your outline and make sure that you know the three, because you may see a question where I give you four, you have to knock the one out that doesn't belong, okay? Again, here we go, strict scrutiny, all right? If anybody gets the strict scrutiny question wrong, I'm gonna be really mad, right? Because all you need to know for strict scrutiny is what? Compelling, 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 and then what? Necessary, right? Compelling, necessary, narrowly tailored, that all is strict scrutiny. Those combinations. Right. Vagueness doctrine is, if something's vague, it's unclear, right? It's ambiguous. You don't know what I'm saying, right? That is a law that fails to regulate speech, that doesn't define its terms, is vague, all right? So we had that law, it was the Fox case, right? Fox versus FCC, where they had the term fleeting expletives, and Cher got in trouble because she said some, I think some F-words on TV. They said, well, you don't know what a fleeting expletive is, and Cher, I guess, F isn't fleeting. I don't know. Whatever, okay? They found it in favor of Fox, because they said, yeah, it wasn't easily defined what a fleeting expletive was, okay? It was vague, and therefore, how could a person know what to say or what not to say? Can Congress pass laws concerning the desecration of the flag, even though it's considered symbolic speech? No, they can't. They've been trying, they try, but they can't. Because it's a, you know, it's protected speech. But in every peaceful or non-peaceful gathering you see, somebody's burning the flag. Okay. All right, so this question here, I'm probably going to ask, not likely anyway, but when you look at speech, the first issue that you have to address is whether the government is regulating the expression of ideas or harmful behavior, okay? If they're regulating the expression of ideas, they're going to be subject to strict scrutiny. If they're regulating harmful behavior, then there's a good chance that that speech is not going to be protected, okay? A law that bans indecent, okay, you see indecent, I don't know what indecent is, what's indecent to me, certainly is indecent to a lot of you guys out there, is going to be what? Overbred doctrine or what? Not really and commonly understood as the vagueness doctrine. That's why that is false. You understand that? Although the government can say you can't have child pornography, it can't ban all forms of expression that appear to be child pornography, because such a ban is likely to capture expression that does not include depictions of actual children. That's true. They can't, you know, so you can ban child pornography, but if it appears to be child pornography, that law is probably not going to be good. You have computer-generated images. You have people that may appear to be a child, but really aren't children because they're older, whatever. Right, that makes sense. A public sidewalk, I thought this was the easiest question, but people got it wrong. A public sidewalk is considered to be a non-public forum. Of course it's considered to be no, it's false, right? It's a public sidewalk, so it's a what?
Public.
A public forum. Fighting words are a form of protected speech. No, fighting words are not protected speech. What else is not protected speech?
Threats.
What?
Threats are not protected speech.
Threats, yeah, threats could fall into fighting words. Defamation is not protected, right? Child pornography is not protected. Obscenity is not protected. So there's a lot of things that aren't protected. Fighting words is not protected either. Okay? We talked about viewpoint neutrality and subject matter neutrality. I don't know if the final will include that. Know this though, which makes sense. Viewpoint neutrality means the government doesn't what? Favor one side or the other. It's neutral. It's not taking a position. All right. And then subject matter neutrality is also known as content neutrality, because the subject matter, the content of what they're talking about is not discriminated based on the subject matter. There's the FCC Fox case. That's the vagueness doctrine. That's the Cher case. The Miller test, again, obscenity. know what it takes to have something obscene, right? There's 4 things for that. All right, let's talk about religion. You have 2 views of religion, the accommodationist view, and then you have what? The separationist view. And one says that the government should accommodate and assist religious organizations at times, and the other one says what?
It should.
It shouldn't. That's right, it shouldn't. Accommodationist says accommodate, separationist says no, there's a wall between the two. You shouldn't accommodate, you should keep them separate and apart. Know the cases, right? You need to know these cases, because you will be asked the difference between these cases. So Levy-Weissman, right, is the coercion test. So you have, for religion, you have the Lemon test, you have the endorsement test, and then the coercion test. That's the order that they come in, okay? Lemon test, endorsement test, and coercion test. The coercion test is the one that is most accommodating, right? Because that's where it falls on that spectrum. So long as you're not coercing somebody to doing it, it's gonna be okay. The Lemon test is the least accommodating. That is the most separationist test, okay? Know where those things fall, you may have a question or two on that. Know what case represents each test. Employment Division versus Smith dealt with the Peyote guy, and that dealt with not the establishment clause, but the free exercise clause of religion. Okay? Those other tests dealt with the establishment on one side and the free exercise on the other. Employment Division versus Smith was the neutral test, neutrality test, and that was for the exercise clause. All right. Again, this is correct. The most accommodationist approach towards the establishment clause, the one that's most accommodating. Don't make this mistake. Remember the order. It's Lemon test, endorsement test, coercion. To coerce somebody is what? Is putting more of a strong arm than to endorse somebody, right? When you coerce somebody, you force somebody. When you endorse somebody, you recommend them. But when you coerce them, you're what? You're kind of bending their arm, right? When you coerce somebody. So, the most accommodation is the coercion test, not the endorsement test. Right? So don't, make sure you know where they fall on that scale. Most separation is going to be the limit. That's not the other thing. It's hard to pass. In which case did the court uphold the 10 Commandments? We talked about 2 cases with the 10 Commandments, right? County of Allegheny versus ACLU, where they said that the 10 Commandments were no good, the way they were done there. And then Orden v. Perry, which they said the 10 Commandments there was fine. So they upheld it in the public display of the 10 Commandments. Now I could ask, in which case did they not uphold it for the display of 10 Commandments? And then the question may, would not be being ordered, but it would be what? One of the other ones, okay? County of Allegheny, okay? In free exercise cases, what do we call that person who's trying to be exempt from fighting in war based on his religious convictions? Yep. What's the name of the Supreme Court case that held closely held corporation could assert religious freedoms under the Religious Freedom Restoration Act that it would not have to provide employee health care coverage for contraceptives? What case dealt with contraceptives? Hobby Lobby. That's it. How do you remember that? Because they don't sell contraceptives at Hobby Lobby, I can guarantee it.
That's what I thought, it was just the super religious.
Yeah, because Hobby Lobby is a store that, the owners of Hobby Lobby are very devout Christians. And their mission is to, sell things that do not, offend the Lord. And obviously, forcing them essentially to provide healthcare coverage that included contraceptives is offensive to their religious convictions, and they said that's the Hobby Lobby case. Okay. The Season's Greetings case with the, you know, the carolers, the Santa Claus, and, the creche display, which is the nativity scene, that is Linsby Donnelly, right? So Linsby Donnelly is the nativity scene, that's the 1984 case, that's the Lemon case, all right, you should know that. Judeo Christian prayer case, saying, in a public school graduation, you know, you can't have a Christian prayer prior to, or that's Levi Weissman. Again, just know these cases that were on the list, and that's really all you need to know, just be able to associate it. Okay, free exercise clause, establishment clause found in Article 1 of the U.S. Constitution. No, that's not Article 1, it's what? Amendment 1. True, false questions, take your time to read them, because it's something that simple, okay? Separationist approach, again, maintains that it is appropriate for the government to accommodate or otherwise assist. No, no, no. I don't know how many people got this wrong, but I was banging my head against the wall. No. The separationist approach does not maintain that it's appropriate for the government to accommodate. No. No. God darn it, no! Which approach says it's okay to accommodate? The accommodations approach. So, read the true false question stuff, because, you know, like I think I'm giving you like softballs, and you guys are gonna hit the test out of the park, and you keep on fouling, you know, foul ball, strike three. Some of these you can't miss, all right? Just read them. I'm pretty sure a lot of you guys know this stuff, and you just, I don't know. I got so many bruises on my head on so many questions, and so many, I hate this time of year. Bumps all over. You guys just don't get the easy ones. I get it, you don't get the hard ones, but the easy ones, nah. Okay, the executive order signed by the president cannot be a violation of the Establishment Clause, since the beginning of the First Amendment includes the phrase, Congress shall make no law. No, that's false, right? Obviously, the president can violate it if he passes a law that's not constitutional too. The coercion test, all right? Now this one's a little more tougher, okay? But it's false, because the coercion test isn't the one that collapses the first two questions of the Lemon test. It's the endorsement test that collapses the first two, all right? So you gotta kind of know the order of these things. The neutrality test, all right, I see neutrality test, I see Employment Division versus Smith, so I'm thinking this is good. Now let me just read it, because this professor's a pain in my ass, and he may be trying to trick me with one word or two, so let me read it slowly. Neutrality test is an approach to free exercise cases adopted in Employment Division that maintains the governmental policies that are neutral in form and generally applied and be deemed constitutional, regardless of their adverse impact on certain religious practices. In Burwell versus Hobby Lobby, all right, so you know the Hobby Lobby case, you know it's providing healthcare coverage for contraceptives. So let me just read the thing, all right? Held that a closely held corporation, which that was, could assert religious freedoms under the Religious Freedom Restoration Act, and it would not have to provide employee health care. Yeah, true. Good. Good. Supreme Court Religious Freedom Act is applied to the states, finding that the act went beyond constitutionally authority of Congress to regulate state policy. Yeah, they said it didn't apply to the states. True. And explain the three tests employed to interpret the Establishment Clause. All right. Well, you just need to know. I'm not going to explain right now, but it's you had the amendment test, the endorsement test, and the coercion test. And that's the terms. right? You just gotta know these terms. So compact theory, social compact, natural law theory, incorporation doctrine. So here's a thing I want you to point out, okay? In matching, and I don't know how people get matching wrong, but they do. Because there's only one answer, all right? Unless it's a matching, sometimes I do, but I don't think I do. Where you can have multiple answers with the same thing. But in these matching, there's 4 questions and 4 terms, right? 1 for 1, that's it. So it's compact theory and social compact, that's basically the same animal, right? One's a theory and one's a term. So now when you go to the answer choices, right? Look at all. Compact theory is a theory of individual liberties that considers liberties to be the conduct of a negotiated contract. Okay, how do I know that's that one? Because it's a theory, right? Social compact is going to be what? A term used to describe the Constitution as a contract between 2 primary parties, the people and the government. So some people see that compact and people in the government, oh, that's the compact theory. Yeah, they're similar, but you got to, put the right one next to it. And then natural law theory is what? A theory. I make them too easy, I think, at times. Okay? And then incorporation doctrine, well, that's the only one left. First of all, I give you a match with only 3 or 4, so you don't have to go through 8 or 9 things to try to match them up. And the incorporation doctrine is a theory that maintains the Bill of Rights, or at least portions thereof, should be incorporated. Incorporation doctrine, incorporated, incorporation doctrine, incorporated, incorporation doctrine, incorporated. Has it hit you? Sixth Amendment, 8th Amendment, 10th Amendment. Again, I break it down to 3 amendments, you gotta know. So, that's it. I mean,